How does premises liability work in the state of Texas? First of all, premises liability is talking about the area of law where a landowner can be held liable for a dangerous condition on his property. You need to know that just because you get injured on somebody's property does not mean they're liable to you for it. You still have to show that they were negligent. Now, premises liability could be a slip and fall, could be a trip and fall, could be a dangerous instrumentalities on the property that injure you. Any of those could fall under that area, even like defective playground equipment. In order to hold a landowner liable, you have to show, first of all, that the landowner owed a duty to you. If you are invited on the property, you're going to have a much higher duty than if you're a salesman coming on there trying to sell something and you weren't invited, or maybe even you're a trespasser. In the latter two situations, their duty is probably just going to be not to intentionally harm you, not necessarily to conduct inspections and make sure the property is safe. Whereas they invite you on the property, you're a business invitee, you're someone they invited over their home, you're somebody a store invited in to go shopping, they owe a higher duty to you when you are invited into their business for their benefit. In that circumstance, they have a duty to inspect the area and reasonably make sure that it's safe. It doesn't mean they're an absolute insurer of the property, but it means they have to act reasonable in making sure that there aren't obvious problems that they haven't addressed. They aren't the insurer of the property, but it means that they do have to take reasonable steps to make sure the property is safe before they let you come in. As the injured party, what you're going to have to show, and the burden is on you to show this, you're going to have to show, first of all, there was a unreasonably dangerous condition on the property. That 2, you were not aware of it. That 3, the owner either was aware of it or that it was there sufficiently long enough that the owner should have been aware of it, that it caused your injuries, and lastly, that you had injuries or damages as a result of that unreasonably dangerous condition. A lot of people don't realize just how tough the burden can be on premises liability cases. The landowners, they all go through training courses on how to deal with insurance claims and accident claims and how to try and keep the area safe. A lot of big corporations come up with these inspection policies where they have people check off they've done an inspection every 15 minutes so they can say, look, we inspected every 15 minutes. Those employees may not actually do that inspection, but you're not going to find that out without taking depositions and asking them what really happened. They're obviously encouraged to say they did because they could get fired if they didn't. Another issue that we see that hurts a lot of these kind of cases is that people don't realize they need to act quickly to preserve evidence in these cases. What do I mean by this? Well, you're going to have to prove that they knew or should have known the condition was there. Unless they came out and told you they saw it, you're trying to prove what they knew or what they should have known without having any direct evidence. The only direct evidence in these cases a lot of times is video footage. The only direct evidence that you may be able to obtain in many of these cases is their surveillance video footage they have in most stores. But if you don't act to preserve that evidence, it will disappear. Let me tell you what I mean. I've seen a case even where somebody came in and they said, hey, I was in this accident, was injured, was doing along, addressing everything with the adjuster. They seemed fine, everything. And then all of a sudden, they just decided to quit returning my phone calls 60 days later. And I don't understand it because they sent me the video. It shows the fall. It shows everything. And so, I've been trying to work with them. And I didn't come to a lawyer sooner because they seemed like they're going to work with me. And now all of a sudden they're being different. So I need help. And I looked at the case and went, well, you got a problem because the evidence that you preserved is of the fall. The evidence that you needed to preserve was of the entire 24-hour period prior to that fall, because that's what would show us how long that spill was on the floor. That's what would show us how the spill got there. You see, if a customer walked up and spilled it right before you walked around the corner and hit it, they're not liable because a reasonable inspection will not uncover that. However, if somebody spilled it an hour ago and all those records that say they inspected the floors every 15 minutes were falsified so that they really obviously didn't because that was sitting there all that time, now you have evidence that they did not act reasonably and that their logs are not accurate, and therefore they are liable for not having made the premises safe.